Sarah on.
All right, this is case number 22 CR 102, Dayton, Ohio versus Dennis Daniel Clarkson. And you are Mr. Clarkson appearing on the screen marked Alicia Snyder.
Yes.
All right. This hearing is being conducted by Zoom. Mr. Clarkson appearing from the treatment facility. The defense attorney is Sarah Barber, appearing by Zoom. Also by Zoom is Assistant Prosecutor King representing the state. Ms. Barber, you and your client both agreement that this hearing may be conducted by Zoom rather than requiring an in-person appearance.
Yes.
Right. Mr. Clarkson charged with aggravated possession of fentanyl related compound, fifth degree felony. Mr. Clarkson, I've been presented with a plea of guilty form here. This is a 3-page form. And on page 3, there's a sentence that says, I enter this plea voluntarily. And right below that is what appears to be the signature, Dennis D. Clarkson, 6/7/22. And is that your signature there showing on the screen?
Yes, sir.
All right. And it looks like you signed this on the 7th of June. Were you in treatment at that time, or were you at Ms. Barber's office?
At the courthouse.
Okay, courthouse, all right. And so you signed this agreement, did you understand this agreement, plead guilty, which means won't be a trial. The next day, your case will be sentencing.
Yes.
And did she explain everything to you and answer all your questions before you signed it?
Yes.
And do you feel you had enough time to fully consider the matter before making that decision?
Yes.
Is it still your desire to go forward with this plea agreement today?
Yes.
All right, now you're entering into this plea agreement voluntarily.
Yes.
The agreement states on page 1 that you're going to plead guilty to the charge of aggravated possession of fentanyl-related compound, fifth degree felony under 29.25.11 Illinois Code. It further states on page 1 you understand that the maximum penalty could be as follows. Prison term could be as much as 12 months, minimum of 6 months when it's imposed. There's a fine of up to $2,500 available, and there's also a license suspension available of 6 months to 5 years. Do you understand that?
Yes.
Are you facing any felony charges in any other jurisdiction?
No.
Are you currently on probation, community control, parole, or police control for a felony in that jurisdiction?
No.
Under the law, Mr. Clarkson, if you're convicted of this offense and sentenced to prison, the law provides that upon completion of that sentence, the adult parole board may, in their option, choose which one was called post-release control for a period of up to 2 years. They don't have to, but they can. If they do, you'll be supervised under those conditions they set, and if they confirm that you have failed to comply, they can return you to prison even though you serve the entire term set by the court for a period of 9 months, or actually in this case half of the prison term for one or more violations. But if you committed a penalty, then in addition to whatever sentence the judge in that new case imposed upon you, the judge is also authorized to sentence you for committing an offense while under post-release control. In this case, an additional period of 1 year, whatever time left on that period of post-release control, if they're greater. In fact, there's that has to serve secondly the sentencing case. You understand that?
Yes, sir.
Under the law, Mr. Clarkson is not required to sentence you to prison for this offense and can't impose what's called community control or probation. That means instead of going to prison, you can be put under the supervision of the probation officer on the term set by the court for a period of up to 5 years. If during that period of time they felt that you were not compliant, they would file a written consent to the court. There would be a hearing, you would be entitled to have an attorney, and if the outcome of that hearing was that you had failed to comply, then at that time the court could revoke community control and send you to prison for 6 to 12 months, finding $25. You understand that?
Yes, sir.
All right, now the charge alleges that on about July 13, 2021, Madison County, Ohio, you did know that it was main possession used. Schedule 2 control substance with a fentanyl-related compound violation section 29.5.11. All right, let's go. So that's the charge. Penalty is described. You understand what it is you've been charged with, what the state's indicated, whether or how they alleged it?
Yes, sir.
Have you discussed the nature of that charge, the evidence of the case, possible legal issues of the case, possible offenses you might try to raise in trial, possible outcome of the trial with your attorney?
No.
I'm sorry?
I didn't understand what you said. I'm sorry.
Have you discussed the nature of the charge, the evidence in the case, possible legal issues of the case, possible offenses you try to raise in trial, and possible outcome of the trial with your attorney?
Oh, yes, sir.
Then are you satisfied with your advice and comments in this matter?
Yes.
Are you under the influence of any types of drugs or alcohol at this time?
No.
Have any threats been made in case you plead guilty here today?
No.
Now, page 2, there are 2 lines printed in bold, and underlined, read as follows. Defense shall not plead guilty to indictment. State defense shall not recommend community control of mission and drug court. Is that your understanding of the agreement?
Yes, sir.
Has anyone promised you anything other than that in case you plead guilty?
No, sir.
Under the law, the matter is sentenced up to the judge. So even though those recommendations should get community control, that's not binding on the court. If I decide after heard all the information that the correct sentence should be adjourned, imprisonment or fine, that could be the sentence. You understand that?
Yes, sir.
All right. And also, as far as admission to the drug court, that would be something people have to discuss with Ms. Sturgis and fill out an application because you have to apply to be admitted to that program. So the court will deal with that at that time. Now, you hold any license or certification from any governmental agency that regulates any occupation or profession.
No.
Right now, you have certain constitutional rights to understand before I can accept the plea. First, you have a right to counsel. Barbara's appointed representative, not sent the word case out, but provide whatever defense might be available to you under the law she wishes to provide. So if you decide you just don't want to do this, you will still be represented by an attorney, by your attorney, and she will defend you and represent you in a trial if that's what you want. You understand that?
Yes, sir.
Now, under the Constitution, you have the right to have a jury trial in this matter, which 12 people will be selected from a group of citizens who live in Hyde County that are summoned for jury duty at your trial day. After they are selected, the evidence will be presented. They get instructions on the law, and that jury would have to decide by unanimous verdict between all 12 have to agree as to whether the state proves your guilt of the offense. Now, you didn't want that jury trial, which you didn't want to plead guilty either way, which means you give up the writing, right, to have a jury trial. In that case, you would have to hold a court or bench trial, which means instead of the jury hearing the evidence, it would be the judge who gave the evidence, the judge would apply the law, the judge would decide whether or not the state proves your guilt. Prove beyond reasonable doubt. Do you understand that?
Yes, sir.
Right, under the Constitution, you have the right to confront witnesses against you, cross-examine for your attorney or court. What that means is witnesses against you have to come into the courtroom and testify. But you and your attorney and anyone else is present. After the prosecutor is done asking questions, your attorney will ask questions. That's called cross-examination. The purpose of that is to bring out evidence to help your side of the case. Do you understand that?
Yes, sir.
Under the Constitution, you have the right to use the power of the court to compel or force witnesses to come to court to testify on your behalf and same as the state. So if you have witnesses you're uncertain going to voluntarily, you request a court release report order less than subpoena, and of course, those witnesses come to court, they go and testify if they wanted to, even though they didn't want to be here, which is the same way the state's witnesses are required to come to court. You understand that?
Yes.
Under the Constitution, you have the privilege against self-determination, which means you cannot be forced to give evidence against yourself at any time, including private. No one can ever make you testify. The prosecutor can't, the judge can't, you make that decision. And if you decide that you do not want to testify, the fact that you did not testify, used against you in any way, by any person, at any time, no one's even allowed to comment about it, except in one situation. That is, if there's a jury trial, you don't testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. You understand that?
Yes.
Under the Constitution, you can do innocent or proven guilty by the state of Ohio every single element of the offense charge. So what that means is that the burden of proof is on you to try to prove you're not guilty, the burden upon the state to prove you are guilty. So a trial, you're not even required to present any evidence in your behalf. You're not required. Whether you do or not, burden of proof will remain upon the state. Prove your guilt by proof beyond reasonable doubt in every single element of the offense charge, which is the highest burden of proof is known under the law. You understand that?
Yes.
Now, you originally pled not guilty. Not guilty plea denied the allegation, denied that you committed any crime, and exercised and revoked all rights I just described. If you plead not guilty to guilt, that's the complete opposite of not guilty plea. Guilty plea admits the allegation, indicted this crime, that you committed that crime, and that plea waives all the rights I've just described to you. Except right to have an attorney, except right to have an attorney, no matter what you plead. That except you plead guilty, waive your right to a jury court trial, waive your right to property against you, property go to court with your attorney, waive your right to the power of the court, tell witnesses to be in court to testify for you the same as the state, waive or give up your privilege of self-determination because the state is guilty, that's what she finds guilty, waive give up your self-defense because the state is guilty, that's what she finds guilty. The subjection can be sentenced immediately by the court. Finally, waive gives up their right to file appeal if you may have or any alleged violation of your rights under this point case down and question sentence you back to sentence. Or under the certain limited circumstances you can file an appeal. That would have to be filed in 30 days and sentencing to be filed. You understand all that?
Yes.
And are you a U.S. citizen?
Yes.
All right, now, you have any questions about the charge or possible penalties?
No, sir.
You understand it?
Yes.
You have any questions about the plea agreement?
No.
You understand it?
Yes.
You have any questions about the constitutional rights of the claim?
No.
You understand those?
Yes.
You have any questions about the plea guilty, what it means, what will happen to that plea?
No.
Now, is there anything, you understand, right? Is there anything you'd like to speak to your attorney about before we go any further? Because I can't put you in no break after you need to speak to her.
No.
And it's your decision to go forward and then plead guilty pursuant to the plea agreement with just steps.
Yes, sir.
And as to the charge which alleged on or about July 13, 2021, Miami County, Ohio, you did not obtain possession or use possession to control substance with offense related compound, violation section 29.5.11, Ohio Revised Code, charge of aggravated possession of offense related compound in 53 felony, carrying possible prison term between 6 to 12 months, fine, $2,500 for possible license suspension, 6 months to 5 years. How do you plead?
Guilty.
Right, the court finds that this day of the court, the defendant applies all his constitutional rights and anyone who tells him voluntary way of saying, Rule 11, plea is accepted as order filed, and is found guilty of the offense as charged in count 1. The court order pre-sentence investigation law will be continued, and we will set the sentencing hearing for August 17th at 9 a.m.
Your Honor,
Yeah.
would it be possible to get that in September?
Oh, okay. Yeah, sure. September the 9th, or September the 7th at 9 a.m.
Perfect.
All right. Let's see. Well, that's a Wednesday. Are you still in Adams County?
No,
Okay.
no, the grant ran out, so I'm back full-time in County County.
All right. Okay. All right. So it'll be September the 7th. All right. Sergeant Jenkins, does he need to call in to talk to make an appointment to see Mr. Wilson, or have you already got that arranged?
We'll reach out.
Okay. All right. You'll be contacted so they can do an interview by phone, and give you the information. You'll need to give them all the information too about your treatment release and so forth. Okay. Thank you. You can go ahead and sign off and leave the meeting. Okay, the jail is there. She's up there. No, she's there, right? Could you bring in Cindy Loud, please? Recording Loud.
Denny hasn't logged in, has he?
Oh, I'm sorry. Wait a minute. That's Denny's client.
Shannon Rohde.
Let's do Shannon Rohde. Miss Barker surgery. Okay, are you Shannon Rohde there at the jail?
Yes, sir.
Okay, this case number 20 CR 219, State of Ohio versus Shannon E. Rohde. This hearing being conducted by Zoom. Present by Zoom is our attorney, Sarah Carter. Present on behalf of the state, Assistant Prosecutor King. Also, Ms. Collins is on the call this is Zoom hearing. This matter is set for sentencing in case number 20 CR 219 for aggravated possession of drugs. Now, there was a new indictment returned against Ms. Rohde on yesterday, and I believe she's been served, but they did not bring her yet. You're aware of this charge, Ms. Barber, for aggravated trafficking in meth from the city to school and aggravated possession of meth, and those are alleged to occur on November 22nd, 2021.
Yes, Your Honor, I was made aware last night.
Okay. You wish to, Ms. Rohde has filled out form of plea, so she is eligible for counsel, so I'll appoint you to represent her. And you wish to waive reading indictment.
Waive reading of the indictment and her plea of not guilty.
All right. All right, well, in light of this new indictment, I'm planning to continue the sentencing until that case has been considered. Is there any objection to that by your counsel?
No objection.
All right. All right, we will set a first pre-trial, well, let's see. Set the first pre-trial for next Wednesday the 20th at 1 p.m. We'll do that Wednesday. Set the final pre-trial for August 17th. We'll do that by Zoom. That depends on your situation, Ms. Carter. So, depending on what your condition is, you can let us know. We can reschedule that if we need to. And we'll set the trial for September 19th at 8 a.m. And we'll defer sentencing until the sentencing until later date.
Time on the 17th.
All 1 p.m.
1.
Yeah. All right. And with regard to matter of bond, Mr. King, is there would have to state.
The state would just ask that bond be set in the amount requested on the bond recommendation sheet.
Carter?
Your Honor, I would state that my client is indigent. She hasn't had an issue showing up for hearings. She has shown up for her hearings. She's shown up for her meetings with me. I would ask that a bond reduction be considered, considering she is indigent.
Okay, well, she's in custody on an after admitting to violation of intervention condition. And I believe that motion was filed when she terminated on May 16th. Yeah, May 16th. But at that point she wasn't calling in. The defense warrant for failure to appear on the penny court in May. And she's been tested positive on a regular basis. So the court doesn't have her custody. So I'm going to go ahead and set bond. It's kind of academic anyway, but I'll set bond on the amount of $25. Plus OR and all the usual conditions that the other order. All right, anything further then?
No, Your Honor.
Would the court consider releasing her to a treatment facility if we can find her a bed somewhere?
Yes.
Okay.
Yeah, you talk about sure.
I'll talk to Tanya.
She can evaluate her and we can decide, or we can see what the situation is that would make sense, I think.
Next week.
All right, thank you.
We'll do Throckmorton.
Okay, have a Throckmorton been picked up, so Deputy Craig, I'll go ahead and give her a case here.
I have the Mylar.
All right, we have the Throckmorton.
Yes, sir.
All right, we have 2 cases here before the court, 20 CR 233 and 2030 or 21 CR 34. Throckmorton, hearing by video, Justice Center. Jesus. Dan, give me those.
Oh, okay.
All right, in case number 20 CR 233, the defendant was placed on control or receiving stolen property. On June 8, 2021. In 21 CR 34, put on city control for failure to appear. Same day. Now, there's been a notification filed by the Probation Department, Ms. Throckmorton, alleges that you have failed to comply with those conditions, specifically Rule 7, that you were given a drug screen at the Putnam County Justice Center July 7th, tested positive for methamphetamine, and then Rule 15, that you owe $1,463 in costs that you made the payments on, and Rule 19A, that you left residential treatment against staff advice on 11/11/21. And I believe you may have had payments out for a little while. Looks like the payment was issued on December 27th. With payments. Now, you are entitled to have a hearing on these allegations, Ms. Throckmorton, in which the state will be required to present evidence that proves that you have committed these violations. And that's not what the purpose of today's hearing is. Today is just to notify you of the allegations. You have a right to have a reasonable period of time to prepare for that hearing. Usually it's a couple of weeks. You have a right to subpoena witnesses to testify on your behalf. You have a right to have an attorney to represent you, cross-examine state witnesses, and advise you regarding each pursuit. And you have a right to offer testimony on your behalf, although you're required to do so. Now, in the event that you are found to have violated these conditions, one of three things can happen. Continue under continued control of the same conditions previously ordered. I can continue them with additional conditions I think are appropriate, including extending your community control up to 5 years. And the third, if it was serious, is I could revoke your community control since you 12 months in prison on actually 18 months in prison on each count. Secondly, for a total of 36 months. I can also fine you $10,000. Now, you have the right to have counsel for an R1 for you at no charge. Do you wish to have an attorney to represent you?
Yes, sir.
All right. Did you fill out a financial disclosure form?
Yes, sir.
Okay. Now, I don't have it, so Deputy, if you make sure you back that up to me. So we will appoint counsel for you and have attorney who's Sydney.
Daniel Witt was her attorney before.
All right, that's fine. All right, we'll appoint attorney Danielle Witt to represent you. 15th at 1 o'clock to the hearing. Be held that on until that time. Notify us whatever appointments and the hearing date. All right, thank you.
Thank you.
All right, now Mr. Kirk is not yet available apparently, so I'm gonna have to shut down this meeting and Deputy, we'll have to sign back in. I've got to go to another Zoom hearing on a civil case, and since we get done with that, I'll sign. If you would just sign back in, I'll probably be about 15 minutes.
Okay, thank you.
Also, the attorney for that as well.
Okay, thank you.
Thank you. Yeah. If you would activate your video, please.
Oh, okay, 1 second. Yeah, 100%. Okay, there we go. Okay.
All right, this is case number 21CV082, County General Health District versus Sean Haynes and Wendland Guthrie. This hearing being conducted by Zoom, Mr. Haynes appearing, also representing the plaintiff is Assistant Prosecutor King and the son of the health department again. This is a hearing on contempt. Normally I don't do these by Zoom, but Mr. Haynes is here. Where are you at, Montana?
Yeah.
All right. And you don't have counsel, right?
I do not.
All right. The records reflect that the court issued an order on default judgments back on January filed on January 14th of this year. Per injunction ordering the defendants to remove all solid waste from the premises, and it was ordered permanently enjoining them doing anything further. Mr. I don't know, did we didn't get any service on this Guthrie, Mr. King?
Hang on, trying to figure that out. Robert.
I can help. This Guthrie no longer owns any of the property. She no longer owns part of it all.
Oh, well, she quit that to you?
Yeah, she sold the remainder of the property to me.
All right, so you're the sole owner.
I
Okay,
sold the rest.
all right. All right, well, Mr. Haynes, the purpose of this hearing is to determine whether or not you have failed to comply with the conditions or the order of the court. Let me ask the plaintiff, has been any change in circumstances of the property since the January order?
I'd say there's been a small amount of the solid waste cleaned up, but there's still a pretty substantial amount of solid waste on the property.
All right, Mr. Haynes, are you contesting that?
I actually, I moved out 3 dumpsters since I acquired the property fully last month. And, I have a contract already paid. They're going to continue work after the holidays, which will be this week. I reinstated trash service to Front-Key, and I intend to have it cleaned up within the next 30 days.
And who do you have a contract with to clean it up?
It is with JWH Construction,
I'm sorry, who?
JWH Construction.
Okay. So are there dumpsters on the property now?
There should be an empty dumpster there right now, yes.
You said that the sun was shaking your head, no, there was not anything there.
As of July 5th, there's no dumpsters on the property.
They said after the 4th, they would have it delivered out, so it would be before the weekend.
All right. So, who's living on the property now?
Nobody is living there. I haven't been on the property in over 4 years, so. But Gwendolyn did have control of the property.
So is anyone living there now?
No, it's empty.
All right. All right, well, what I'll do is I'll continue this for 30 days or so to give you an opportunity to, and I'm gonna wait for a report from the health department. It's been 6 months now, since the order of the court, almost 6 months. So we're gonna give you another 30 days, but if you don't have it cleaned up, I'm gonna just have a report date. I want to report 30 days from the plaintiff as to the condition, and if they don't feel it is in compliance, then I'm going to reschedule this and order you to appear personally. Because this is a contempt citation, and if you don't appear, when I issue that order, then there'll be a warrant issue for your arrest. And, you know, it's possible that you're not going to do this cleanup, that the plaintiff can ask for a receiver to be appointed and have them come in and clean the property up and assess it against the property, and if you don't pay it, have the property sold at a sheriff's auction and pay the fees that they've incurred, and if there's any left, then it will be distributed. So this is something that needs to be taken care of, and needs to be taken care of quickly. All right, understand?
Like you said,
So there's going to be 30 days. I want to report from the plaintiff 30 days from today. And if they indicate that you're compliant, then the case will be, the contempt will be dismissed. We'll have to pay the court costs. If they say that it's not compliant, then there'll be a hearing set. Now, that means you need to stay in touch with the health department, Ms. Huckleberry. You have her number?
I do not.
All right, give them your number, Ms. Huckleberry, please.
It's actually Mr. Webb that's handling this.
Oh, Mr. Webb, okay.
His husband's just covering it today.
Okay, well, give him Mr. Webb's number.
937-393-1941.
If he's not there, you can leave a message. That's their primary number at the health department.
Yes.
All right, thank you.
Thank you very much.
And now we'll go back to the journal hearings and see if my minutes here.
Recording in progress. Recording stopped.